employees have the rights to wage information. You can't engage in protected concerted activity to improve your wages if you don't have the information. And what we have seen is many companies have rules or policies which make that information confidential and do not give it to employees. The National Labor Relations Act in Section 7 protects the rights of employees to engage in protected concerted activity for mutual aid or protection or for collective bargaining. For our purposes, we're going to be talking about mutual aid or protection. It involves protecting employees whether they're union or non-union employees. That part of Section 7 is enforced by another section of the Act, Section 8A1, which makes clear that employers cannot interfere with employees engaging in protected concerted activity. So, what is protected concerted activity? That is two employees getting together to work to improve wages, hours, or working conditions. It may mean also an employee who acts alone, but who may be considering and discussing it with other employees before he or she acts, or it may be the person acting on behalf of other employees. Employees have to have access to that wage information for them to be able to engage in mutual aid or protection. I'd also like to note that discussion of this sort on Facebook or Twitter or other social media also has protection under the National Labor Relations Act, as long as we're involved with protected concerted activity and it's to improve wages or other terms and conditions of employment. What's not protected is trade secrets, confidential information about customers, information about how a company operates. Here we're talking about wage information so that employees are able to know what they're paid and are able to perhaps work with other employees to increase their wages or change other terms and conditions of employment.